just before we start, I'll just introduce myself. I started life as a civil engineer and then did economics and then did law. And progressively I've specialised in where engineering and economics and the law overlap. And that's a field that's both entrancing and it's a field where one can demonstrate skill and understanding and requires continual learning. So as a function of today, my firm, Doyles Construction Lawyers, is interested in presenting topical topics so that people can get an understanding of how they should run their construction contracts. So on that basis, I'll move then to managing extensions of time claims, and it's a very important part of the construction process. The reality is that you have a trade-off between quality, time and cost, and managing the time aspect of construction contracts is not only demanding but enormously important. So if we go through to the next slide, we've got a statement here of some of the topics that are relevant and have to be applied in any particular construction contract. The overwhelming delays and extensions of time are analysed under the critical path method analysis, but that's only one model, and although it's popular, sometimes it needs sophistication and sometimes it needs a different model to apply. So while one deals with extensions of time, one then has to have a model in which to measure the extensions of time, and those models can vary. The critical path works best when you have a series of constrained steps which must be followed in a precise pattern in order to get to the end result. Some contracts, perhaps the construction of a road, you could start it in the middle, you could start at either end, you could start it in the middle and either ends. But on the other hand, if you're building a building that's 30 stories high, then of course you've got to start at the ground floor and work your way up. So that's important when you're looking at critical path, because the circumstance is that a critical path will often be a situation which is either agreed or adopted as a proper method of measuring the time on a construction project, but it may not be compulsory. That is, there may be a number of ways that you could complete the building and a number of sequences that you could employ. So you need to be alert to whether or not a particular model operates sensibly and favourably in your particular project. So if you look at critical path methods, you've got to define the extent of delay. You've got to look out for any resource constraints. That is, if you've only got one particular machine that's necessary for the work and that machine is out of action, then of course there'll be a problem on the site in terms of delay. Simultaneous and parallel delays we'll look at, as well as delay costs. So these are all concepts which apply in many of the extensions of time or delay claims that you'll be dealing with. The other aspect is to understand how extension of time clauses operate in respect of liquidated damages, which are also a almost universal characteristic of a construction contract. So when we look at it, time does matter, and delays create cost and risk to the project. So the issue of a project manager must be on guard to ensure that the time is being observed, as well as managing costs and quality. The situation of delivering a project a year late is reasonably mission critical to a contractor who otherwise will have to deal with the liquidated damages, but also a loss of profit from his own side, where the extension of the construction period extends his delay and his overheads past the budget that he tendered on. For the principal, delays cause holding costs and financial pressure because funders don't want late projects. They are concerned to have the projects delivered on time in order that the projects can start earning their way and paying back and securing the financier. Again, if a developer gets caught with a late project and that is tending to make it financially uncertain, then financiers are concerned and will often step in to effectively wind up a developer and introduce a better discipline to the project. Additionally, tenants.
There you go.
Yep.
No.
Sorry. So the situation is that tenant disputes are often caused by late projects. A tenant will want to come in at a certain time and to make sure that the his business is not affected by the problems of the contract. Time matters, affects project cash flow and reputation, commercial certainty, and effective EOT processes make it easier for people to look to. So extensions of time, they refer to changes in the contract's date of completion, and they are, you've got to distinguish between the date for practical completion and the date of practical completion, one being the target that's set in the contract and the other being the actual achievement of practical completion. The EOT clauses allow contractors in principle to extend completion dates for valid reasons. Those valid reasons are found in the contract. The important aspect to note that as a baseline for this legal analysis that we're introducing is that the law would say if you've agreed to complete a contract by a certain date, then you've got to complete it by that date. And there isn't too much leeway in that situation. On the other hand, the situation is that if the principal delays the project, then the circumstance is he won't be able to insist on liquidated damages or a particular time of completion unless he's got a specific clause in the contract that allows the completion date to be adjusted. So it's important that we have a contract law scheme developed when life was tougher and that the laws develop some firm rules as a basis for contract, and those firm rules then are adjusted by the terms of the contract. So it's important to ensure that you've read through the clauses and you're carefully administering the contract in accordance with those clauses. The EOTs you'll find in standard contracts are found in various spots, AS 4000, and you must give notice within time. That's a feature of delay clauses. AS 2124, similar situation. HIA contract allows for extension in broader circumstances than those other clauses. And effective EOT clause balance discretion and certainty, preventing time being set at large. If the principle fundamentally prevents the timely completion of project, the law's natural remedy is to set time at large. Effectively, that means that the contractor might then only have a reasonable time to complete it in and a much more forgiving timetable. So some of the aspects that you've got to look at when you're dealing with these situations is that design and construct contracts often increase the contractor's risk for delay, because the more responsibility the contractor accepts, then usually there's less cause to give an extension of time. Whereas in a AS 2124, if a design improvement or adjustment is late, that's usually the principal's problem, and the circumstance is in a D&C contract that is the contractor's problem, and he has a tighter timetable to respond to. The EOT clauses should account for design approvals and also drawing delays. If somebody wants something amended, then that's going to have to go through a cycle of approval, and that often causes substantial delays. The review and approval is best time-bound in the sense that it's best to have an agreed period where the design approvals or the design adjustments provided by the contractor or the principal's consultants are laid out so everyone knows where they're going. Got a reference to Main Tech Services case there, and that's where a contractor successfully obtained extensions of time and delay costs where design interaction caused delay. That is, if the principal's messing about with his design late in the construction process, he's obviously going to cause delay to the contractor in getting supply chains in place and then installation in an orderly manner. So the issue is to anticipate some of these problems and therefore avoid them. You'll often hear some terms thrown around in the area, and one is excusable delay that's caused by factors outside the contractor's control. It may entitle you to an EOT. Compensable delay, that's excusable delay where the contract may also be entitled to delay costs. So say, for instance, a breach of the contract by the principal, you usually get compensating delay for that. Inexcusable delay, of course, is caused solely by the contractor, and there's no entitlement to an EOT, and if you don't finish on time, you're liable for liquidated damages. The other aspects that are connected with it is disruption, because it may not be that you're delayed per se in the completion of a construction contract, but it may be a situation where your completion of it is disrupted. Take an example that I was involved in a few years ago where there was a casino to be finished, and the situation was that towards the end of that process, the subcontractors were put under enormous pressure to finish the work within the allotted time without any extensions. And that meant that they had to work in and around and over other subcontractors, so painters, plasterers and plumbers, electricians are all working perhaps in very common areas, and that led to a lot of increased costs for the subcontractors. And their claim was more for a disruption rather than to a particular delay, because there wasn't an extension of the works, there was a disruption of the works. So the situation is that is also a issue that's relevant when you're considering EOTs. The other aspect is when work is suspended, and generally there is a provision in most reasonable contracts that the contractor would get his costs of demob and remobilisation and some agreed amount or reasonable amount in the period of the suspension. Of course, if suspension is caused by the fault of the contractor, then those entitlements would be usually lost. The other aspect, coming back to the CPM requirements, is that it's identifying critical paths as opposed to parts to items of work that have float or are able to be done with some lag or catch up. The classic example of critical path method is preparing a cup of tea, where there is a critical path that probably runs through the boiling of the water, which takes most time and controls how fast you can do it. Whereas if you have to obtain cup and saucer and ingredients, you can probably do that either as the kettle is starting to boil or as it finishes boiling, as long as you've got it ready to take the hot water. And therefore you have a critical path through the hot water and a non-critical activities without that restriction. The situation then is when you're putting in an extension of time or considering an extension of time, it's important to identify whether or not the activity was on the critical path. And that critical path can vary during the conduct of the construction period. And it is to a certain extent influenced by events, and to a certain extent it's by choice. So for instance, the plumbing rough-in might not be on the critical path, but on the other hand, if the plumber can only come 1 week in August, then the situation is that might well be a critical activity. So there's a bit of choice and a bit of analysis to go into deciding what is what items are on the critical path. Usually, again, in any complex project, a programmer will be employed to calculate and maintain and manage the program. But it's important that every project manager has a grasp of the essential principles and their application. The situation is there's a couple of cases where that was considered as important, and they've got pro-bill there, which is the importance of assessing delays within the critical path and then applying the prevention principle to variations. So there the court said, well, you've got to look at the critical path, but then again, if you vary the work on the critical path, one could expect to cop an EOT claim, probably with costs. And again, that the right to rely on the principle is not absolute. Sometimes parties to a construction contract are contracting out of the operation of the prevention principle altogether. An example of that is, for instance, somebody who's a principal who's keen to get his project delivered on time, and he says, look, I may order variations, but you've agreed to bring on to the varied work sufficient extra resources so that you don't have an impact on the progression of the project. So there the contractor would be given perhaps a more generous cost in order to get the varied works done, but he wouldn't be given an extension of time. Now, again, the contractors who are the principal and the contractor can agree to a regime like that, and you've got to look at the contract in your particular case to make sure you're applying the right principles. So the situation is that you've got to look at the programming obligations under your contract. Many contracts now impose express obligations to submit an update program. And it's important that you get a workable scheme as doing that, because with a few complications, otherwise the program becomes hard to submit, hard to present sensibly, and can cause problems for the person who wants the extension of time. So a contractor puts in extensions of time. If he's given a result of those pretty quickly, that is within, say, 5 days or something, he can easily adjust the program in order that he has a clear basis on which to submit to the next EOT. But if that decision doesn't come back, he then has very complex situations where he has to adopt, the base program with his first claim not approved, or the base program with his first claim approved, and then develop the basis for his second claim. So there's a lot of complexity into keeping up to date with the programming requirements and having the superintendent approve those programs regularly. Again, if they're not agreed, the extension of times are not agreed, then they'll have to be properly notified and perhaps reserved for dispute at a later stage. The failure to comply with the contract aspects is very important, because as we'll see through a procession of cases, if you sign a contract that says you're going to do X before you get Y, then if you don't do X, you won't get Y. And the law operates on a fairly tough-minded, logical sort of basis there. So it's important that you preserve a clear view of your programming obligations and the extension of time claims you've made in order to keep things pristinely clear. Again, you'd have a baseline, or the program that you started off with, and the actual program that's now being carried out. There might have been some agreed extensions of time to that program, with or without money, and then there'll be perhaps some disputed EOT claims. But you've got to present those very carefully. Again, in this case of Gaymark and Walter Construction is an example of where LDs were imposed because the delay was not properly substantiated. We'll talk again of substantiation, but it's important, first of all, to make sure that your program is clear and that you can identify your critical path and that you can show that delays related to the critical path. And you've got to remember that in the programs you present, you must be careful to make sure that all critical activities are identified as critical activities. Otherwise, EOTs will be much harder to obtain in the future. So one of the things is you've got to realise that most contracts will put tight timetables on notification, and they often have 2 or 3 steps. That is, you've got to notify when the delay is anticipated, notify when the delay commences, and notify any continuing delay. So all of this should be prepared before you start on site. You should have set up some templates for advising on extensions of time claim and make sure that your programming was sufficient to support those claims. The case here of ADC and White Constructions, the contractor failed to give timely notice, was noticed non-compliance fatal, and yes, it was. The contract's barred from EOT due to failure to comply with mandatory notice requirements. And again, it's important when you're negotiating contracts to make sure that you have organised practical time limits. It's one thing to say that you've got to notify it within, say, 7 days, which means you have to notify effectively once a week. But if you have to notify every 2 or 3 days, it often becomes a very onerous burden, because it doesn't fit into the cycle of your management of the job as per every week. And it means that instead of notifying 4 times a month, you're sort of notifying 15 times a month, depending on the time limit. So it's important to negotiate a proper basis. One aspect that's coming into modern construction these days is the Unfair Contracts Act that's been brought into federal level. And basically that says in certain circumstances, depending on the size of the contractor, an unfair term is and can be declared by the court to be void. There are demanding preconditions to that effect, but fundamentally it's seeking to rebalance the general common law, which was pretty tough on contractors in this respect, to a situation where a more reasonable regime would be accepted. So there's a case there of the ACCC versus Fujifilm, when unfair time limitations in a standard form contract were deemed unenforceable. So the situation is one should agree and negotiate to have reasonable provisions, and then one should comply with those provisions very carefully. You've got, of course, in common delay events, you've got principal caused, contractor caused, and neutral. So weather, unforeseen site conditions, pandemics, they're all neutral. And usually they might allow a contractor time, but they might not allow him money. Whereas for principal caused delays, usually he might expect the extension of time together with some delay costs. But for contractor caused delays, usually he won't receive either. So it's important to make sure when you're putting an EOT claim together that you've carefully positioned the claim in one of the other categories that gets you some reward. Usually, again, substantiating delay is important, and you've got to take it as a contractor that what's obvious when you look at site today might not be obvious when the delay claim is assessed in perhaps a week or 2 weeks or 4 weeks' time. So you've got to look at proving in lots of cases, proving the obvious. If you take a picture today about the flooded trench, then the situation is, provided your metadata of time, date and location is pretty good, then that should be accepted. If you try and describe the extent of flooding in 4 weeks' time, then it'll be clearly sort of contended that you've embellished the flood. Whereas if you take the evidence at the time and you make sure that everything's observed and recorded, you're likely to have a better result. The impact on the critical path should be measured. So you should have an argument as to say, well, there's a flooded trench. That meant I couldn't get the crane into the building. That meant I couldn't lift the stores that I needed for the installation of the air conditioning. Therefore, there was a delay on the critical path. And then you've got to look at the duration of that impact. One, not to unduly exaggerate it, and then again, not to unduly minimise it. If the crane can't get to that area for a day, that might be okay, and that's 1 day's delay, but there might also be other delays about it, in the sense that it may be that there's then more urgent work to be done by it, and it can't get to the work that was meant to be done during the delay, so that there is more delay associated with it. Additionally, you can get consequential disruption in the sense that it may not have been able to get to the correct spot, and therefore its listing of the materials is out of whack and required sort of more handling it once it was loaded. So it's again a matter of writing up and keeping a good site diary to connect these things together and make sure that you're able to be properly rewarded for a delay not your fault. It's important as well, though, that not only do facts matter, but logic matters as well. The circumstance is if, for instance, the crane could access the site from another entry point, or there wasn't a delay on the actual installation because the materials were not necessary for the next few days, then of course the EOT will be harder to justify. The other aspect that should be looked at is variations and delay and their interplay with extension of time claims. Variations, which stands for any claim you can't give a better name to, together with any change in the work or the method of work or the sequence of work, they often don't involve an EOT. If, for instance, you're varying the colour of the front door, then that's probably not going to get any extension of time, provided it was notified some distance out from the door's installation. On the other hand, some EOTs cause a major interruption to the construction. Say, for example, a commercial building, and there's a variation which says, don't do the kitchen. We've got the kitchen from somewhere else. We don't need you to do the kitchen. The problem from the contractor is, well, exactly how much of the kitchen is not to be supplied. So there's delay and confusion while they define the interactions with services, interactions with air conditioning, and interactions with the ceiling that's to go in there. So it's important when you look at variations, they have quite an element of specification and design to them in many cases, and that causes delay because all of those things can't be organised in an instant. The issue, however, for a contractor is to be very careful to respond back to any unclear variation with a request that it be properly defined as soon as possible, and noting the delay might be a result of it. The other aspect is it's proper when you do a variation to watch whether there is an EOT. So the situation is for every variation, one should look to see whether there's resultant EOT. Oftentimes you find that while it wouldn't appear on the surface, a closer examination means that there will be at least some time reorganising supply chains, reorganising subcontractors, and reorganising a schedule of works in that area. Defining the extent of the delay, the situation is again coming back to this aspect that if you don't notify and if you don't explain in your notification the substance of the delay and its relationship with the critical path and its duration, then you may not get much sympathy. This one of Australian Development Corporation and White Constructions, a contractor failed to provide the notice of delay within the 30 days, and it was false. It was considered fatal to the right to subsequently make a claim for the EOT. And the circumstance is you'll set out there that Giles J. Explained the mechanism. He said it was included in the contract for a purpose, and the purpose was clear, and the mandatory terms shall notify, and that meant that if you didn't do it, you didn't get your benefits. So it's important that you're aware of that, and as a contractor, on top of it. The other aspect is an older case of Peak Constructions and McKinney. This was where the principal sought liquidated damages from his head contractor, which in turn sought liquidated damages against the subcontractor. Found that the principal is not entitled to recover liquidated damages where the 58-week delay was caused by the principal itself, and the head contract did not entitle the principal to extend the time for its own delays. That's the important rider. So the situation is that if you don't have a clause that allows you to extend for your own delay, then your own delay will set aside the program if you cause delay. Again, a question of Turner Corporation, and in this case, the Supreme Court of New South Wales found that the prevention principle had no application due to the existence of a clause entitling the contractor to an extension of time in respect of preventive actions by the principal. So therefore, where the contractor had not applied and had not satisfied that clause, he was found not to have any release from the prevention principle. The prevention principle is an important principle, but it isn't unlimited, and the terms of the contract will provide whether or not it applies in any particular circumstances. So the situation then is that if we look to the prevention principle, and it applies not only in extensions of time claim, but in contract rather more generally. And it says that a party can't enforce liquidated damages if it causes delay in the contract provides no mechanism for relief. So the purpose prevents injustice, where a contractor is prevented from achieving practical completion due to the principal's own default. And it's relevant only when the extension of time clause doesn't allow the principal to adjust the time for completion. Again, going to, excuse me, a concurrent delay, and this is a constant sort of issue. If there's delay by the principal and a delay by the contractor that happened at the one time, what happens? And we first of all look to the contract to see what contractual provision has been made for that eventuality. The circumstance is that if the situation is that there's concurrent delay, a usual approach might be to apportion it. But the circumstance is that if there is a provision which says in concurrent delays, one party gets the benefit and the other party doesn't, then that contract will take precedence. So that it's important that you're aware of what the rules are. For instance, a principal suspends work on the project, and then the contractor has a flip out with his equipment, and that's out of action for a week. Then the circumstance is the contract might provide that the contractor doesn't get any extension of time, despite him being prevented by the principal from doing the work because his equipment wasn't available to do it. So it's important that you again watch yourself. If the principal is delaying as a contractor, you should make sure that you're ready and able to work at any stage during that period of delay, that you maintain a readiness to work in order to obtain the benefit of the extension of time. I might go to the complexities where you have delay risk allocation that messes up between subcontracts and head contracts. On the one hand, one would think that if the subcontractor is delayed for a day, then the head contractor will therefore be delayed for a day, and therefore the head contractor will grant an extension of time of a day and then claim a day off the principal. However, there's a problem in the back-to-back, because if for instance, the subcontractor has to notify within 7 days of the delay, but the principal contractor has to notify within 2 days of the delay, then it may be that the notification of the subcontractor who's delayed by the particular event will come to the principal contractor too late to be notified. So it is an issue that you need as a head contractor to align those notification dates so that they work coherently. The issue is, again, looking at proof of delay costs. What you've got to do is to make sure that you can prove things, so labour and plant records, preferably related to the issue. There's no point in just having a reference in the site diary to there being 10 men on site, unless you've also got the site diary to record that as from 2 p.m, all 10 men were stopped from working by X. So you've recorded the impact on the works of the particular event. The other aspect is equipment hire costs. They're often a point of contention, because on the one hand, if you've paid off a Fergie tractor and you're using it on your job, on one level you could say, well, it cost me practically nothing. It's just the fuel and a bit of repairs every few months. On the other hand, one could have a situation where the cost of getting another Fergie tractor to come in and help with your project might be $100 an hour. So it's very important to, when you're setting up a contract as a contractor, to make sure that your equipment hire costs are carefully recorded and properly administered. Oftentimes a contractor should have a separate equipment company which owns the equipment and leases it to the operating company, and under properly drawn agreements that can require and give meaning and proper recording to the equipment hire that the operating company incurs while there's a delay. The other aspect with equipment hire is that the length of hire varies the amount substantially. So if you're going to acquire a rock breaker of a certain sort of weight and power, then if you hire it for a day, it'll cost you perhaps, say, $5,000 a day. But if you hired it for the whole week, it would perhaps cost you only $15,000. That is, you get substantial 40% discount. And if you hired it for 3 months, you might get it for a lower cost still. The proper measurement of equipment costs is important, and it's often a leading component of contention and value in any sensible delay costs. The other aspect is site overheads. Again, the situation is that you should be careful to record your site overheads, careful to make sure that all of the equipment and accommodation that you've provided as a contractor is fairly recognised. The pro build case again, entitled to an EOT due to delays caused by variation. This Hero project is another demonstration of the prevention principle in a matter outside strict construction. The purchaser of land sought an injunction to restrain the vendor from terminating the sale contract. Obviously, it was an attractive purchase where the plan of subdivision was going to be late. And the purchaser argued that the vendor had breached its best endeavours obligation to get a prompt subdivision plan. And there the Supreme Court applied the prevention principle and held the vendor prevented the purchaser from settling, and that the failure of the vendor to comply with its obligations prevented it exercising its right to terminate the sale contract. So again, it's an important principle. If you cause the default of your contracting party, you can't then rely on it. So that's an important aspect. There are a number of cases there that I've covered to provide the examples of the practical application of the prevention principle. So again, you've got the Mole case versus Morton, where is in breach of an obligation, and that breach in turn caused the other party to also be in breach. The first party cannot usually complain about the second party's breach. So again, just simply reinforcing that important principle. The prevention principle has to be looked at in the context of the contract. It can be excluded, or alternatively, it can be included in certain circumstances, depending on the conditions. So it's an important principle, but it's important to make sure that it's correctly applied. So if we look at sort of things that we can look at with extensions of time from both the perspective of the contractor and then the principal, one is to make sure that you've given yourself appropriate sort of balance in the events that you've programmed to carry out over the course of the contract, and not to allow sufficient time for the initial activities. Often means you're going to be running late, or apparently running late all through the job until you get to the end. So it's important that you start with a sensible program at the end, and a realisation that unless you do, you're going to be in delay case throughout it. The other aspect is to immediately recognise delays, so that sometimes delays go on for weeks or days or months, but then somebody realises, hang on, we're not getting ahead on this job because the rock condition is too hard. Understanding delay, recognising delay against your program is very important. I've been on jobs. One particular job is a tunnelling job in Fiji, and everyone said, well, the workers are hopeless. They can't get this job done. We'll have to change leaders and teams and everything to try and get somebody that can work. But really, the situation was the ground was later on proper geotech analysis to be particularly hard, and that should have been recognised at the very earliest time. So it's important to use your programming not just as a form to be filled in for the purpose of EOTs, but also as a guide to you as to realise what's going on in the job and whether or not the time is being eroded by factors that haven't been recognised. The other aspect is, of course, is you've got not to wait for the superintendent to recognise when an extension of time is claimed. It's the contractor's sort of duty and obligation and responsibility for self-preservation amongst anything else to notify the claims early. Got to comply strictly with the notice provisions, and you should read them to make sure that you've understood them and that you have the templates of a claim ready to go. Once a issue emerges, it's often all hands to the wheel to try and resolve the problem, and that the notification is forgotten. If you've got it ready beforehand, then you're in a much better situation. The other aspect is substantiate the claims to make sure that you've recognised the various elements that go to make up a good claim, and you've got a logical explanation together with the records to back it up. And the circumstance is you've got to watch how you're incurring your costs and recurring your costs, because unless you can segregate your costs as you go, that is, this team is working on that work and that team's working on this work, and we keep their records crisp and clear, then it's often impossible or very, very difficult to justify the costs that have been incurred. And then again, for principals, is to proactively monitor the program and realise when your contractor's having problems in keeping up with it, where something's going wrong. In lots of ways, signing a construction contract is sort of entering a sort of a joint venture. And if somebody's suffering on the contract, then it's likely that both people will suffer. So active management and active monitoring by principals is important to ensure that appropriate steps are taken if there's a delay. The best advice, I think, is to have a superintendent who is on the job, but also reasonably neutral. Often the contracts these days say that he's only an agent of the principal, but the loss of some professional independence often creates problems for both parties, and it's certainly a desired aim that everybody has a superintendent that can bring a bit of common sense to the assessment of claims in order that the contract can be efficiently carried out. The other one is don't ignore potential delay events. If they're occurring, the situation is that you should be alert to them, and the great potential for the construction industry to develop a lot of waste is demonstrated where everybody thinks, well, it's the other person's problem, so I don't need to do anything about it, rather than saying, look, if there's a problem on the site, let's get it fixed, because the sooner it's fixed, the less damage it'll do to either of the parties. So the other aspect is, of course, is keep contemporaneous records for both parties is essential. Build relationships, because if you can agree things and if you can work in a collaborative way to resolve difficulties, then whoever pays will only have to pay a small amount for the challenge that's been presented. But if you get adversarial too early, too often, and too violently, sometimes that reacts to the disadvantage of everybody concerned. understand the contract, because the contract will govern the circumstance, make sure that you're on top of your obligations and discharge them, and sensibly expect the other party to do so as well. So that's all right. There is in the slides, which I think we can send out to you, a number of checklists. Are the program baseline submitted and approved? Are the cause and durations documented, etc.? So the situation is that that's there. I'm coming to the end of my time today, but one of the important aspects is to look at EOTs in adjudications, in security of payments applications, and there one needs to have a clear and straightforward principle of, for the contractor who's claiming delay and costs of it, a certain amount of clarity in his claim. Ideally, for the contractor, he would like to have a situation where there is an entitlement to get delay costs. It's not a claim for damages, because a claim for damages won't work in SOPA, but it's a clear provision that if I'm delayed for these days, then I should get this amount per day, and that amount is an amount that I can claim. So again, in Southern Hand breakfast point there, it was emphasised that there was a need for a contractual entitlement for the SOPA claim to succeed. So you can't have a situation where you say, well, you've interfered with me, you've breached your contract, there's a claim for damages and I want this amount, because the SOPA claim won't respond to that. So it's important to provide and agree at the time of the contract what causes delay and for what clauses one gets an entitlement. The situation is we've run over some of the key legal principles and some of the warnings about notification. The circumstance is that I'll end on that. You say that effective management is essential for construction, understanding some of the key legal principles and the cases that have been decided, and the circumstance is the need to manage it as any other aspect of the construction. Oftentimes you find that a contractor wants to do a delay claim towards the end of the job, and while he's been very fastidious in making sure the job is done well and making sure it's well organised and well run, the situation is he hasn't bothered to put in any extension of time claims, and therefore he affects himself substantially. So make sure that those steps are required.